Okay, good morning, everybody. Happy Tuesday. Here we go. We're going to kind of wrap this up this week. And we're going to be talking about some of my favorite subjects of the whole RPA. At any rate, I want to point out, guys, you really need to pay attention and maybe go back and watch some of these classes again, because here's the problem. I have the top agent in the company come in and sit down in my office yesterday, absolutely beat down because a big sale is going on and the sellers are just livid, and she's the listing agent, are just mad because the buyers have not performed exactly as expected, which is rarely happens anyways. But she did not follow the contract specifically and left out a very important thing before the seller could cancel or give them the right. And that just kind of fuels the whole fire. So when I tell you, then you go through this contract and you read that in 17 days, the buyer has to remove their contingencies or cancel the agreement, which is what the contract says. By the 17th day, you need to do that. You don't wait till the 18th, 19th, 20th, because when it goes sideways is when everybody comes to me and everybody starts looking into what does the contract say? And it's too late. It's too late at that point. You have written authorization from the buyer and the seller, the principals, to do this particular thing. The issue that we're having right now is to do with the demand to close escrow. Buyer's supposed to record their sale by tomorrow. If they don't get their funds and transfer them today, they're not going to do it by tomorrow. Seller's livid and upset and already drug around by the buyer, they feel, and so they're upset about that, and they're looking somebody to blame. And the agent is saying, I guess I should have sent the request to close escrow now, but they didn't. So at any rate, pay attention to what is being said, what's being written down, read it, understand. If you have any questions, see me or Mandy about it. It's going to be critical, not maybe now, maybe not most of the time, but eventually something's going to go sideways and you're going to come to me and we're going to have to start explaining why I said what I said, because I'll play these for you to remind you. All right, guys. So here we go. Scope, a very important section here. We're now, I guess, on probably page 8 or 9, whatever it is. We're looking at the scope of duty. Very, very important that you do not step outside of this. You don't have written authorization to step outside of this. I go down to the city and do all the inspections for that's not a duty that you have. You do not have written authorization to do that. You are stepping outside of your agent's duty. So let's take a look and see what it says. So buyer and seller acknowledge and agree that the agent does not decide what price the buyer should pay or the seller should accept, does not guarantee the condition, does not guarantee the performance or adequacy of completeness of inspection, services, production, products, or repairs made by the seller or others, does not have an obligation to conduct. You notice how it's saying does not. So we're limiting the scope. We're taking the scope of duty that the seller or buyer thinks that you do everything, and we're narrowing it down to what you really do and what you really have authority to do. Does not have an obligation to conduct inspection of common areas or areas off-site of the property. You don't go down the street and talk about the noisy neighbors down there. That's an off-site inspection. The sellers have to do that, not you. You shall not be responsible for identifying defects on the property in common areas or off-site unless such defects are visibly observable and an inspection of a reasonably accessible area. In other words, you're not required to crawl up in the attic to look for defects. You're not required to crawl underneath the house to see what's going on under there. That's not reasonably accessible. The buyer, the agent, shall not be responsible for inspecting public records, permits concerning the title or concerning the title of the property. Don't do it. That's what title is for. Don't inspect those records or permits. That's not your job. You're not really trained for it, number one. Number two, you're going to open yourself up to liability and have to say, yes, Your Honor, trust me. Shall not be responsible for identifying the location or boundary lines or other items affecting titles. Shall not be responsible for verifying square footage, representation of others, or informing contained in investigation reports, multiple listing service, advertisement, flyers, or other promotional materials. We don't measure the property because everybody has a different opinion. You could have 3 different appraisers measure a property and get 3 different opinions of what the actual square footage is on it. So don't get involved in that. If you feel you must, and I don't really like the form, but if you feel you must, fill out that square footage stupid form and list the different areas that the square footage comes from. That's up to you, but I don't require it. I don't even want us going there. The agent shall not be responsible for determining the fair market value of the property or any personal property included in the sale. Agent shall not be responsible for providing legal or tax advice regarding any aspect of the transaction entered into the buyer-seller. If it's a legal question, if it's a tax question, see your attorney or see mine. See your accountant or see mine is the only thing that you can tell them. You shall not be responsible for providing other advice, information that exceeds the knowledge, education, and experience required to perform real estate license activities. Buyer and seller agree to seek legal and tax, insurance, title, and other desired assistance from appropriate professionals. Okay, so that's the scope of the things that you do not do. Don't get involved. Every one of those areas have gotten real estate agents in trouble, sued, laws created because we overstepped our boundaries. What are you hired to be? You're hired to list and sell real estate. That's it. You're not there to inspect the property as to termite damage. You're not there to inspect the records at the city that they are in and correct, and that you're not there to measure the property. I had to. When I took listings, when I first got in the business in '84, we had to go out and measure the properties. We got in all kinds of trouble for that. So don't do it. Questions about any of the thou shalt nots? Any questions? Nope. Okay. Remember in the very first class, I said that this contract is actually 3 documents in one. It is the terms and conditions under which the seller and buyer will purchase and sell the property. It is a receipt for the initial deposit, and it is joint escrow instructions. Instructions to escrow telling them how this escrow is going to proceed. So this is the section that covers all that. And I'm not going to go through the paragraphs, but here's where you would go. In 19A, you just look up these paragraphs. All of these paragraphs are directions to escrow as to how this escrow will proceed. Now, escrow itself also has their own additional instructions that they will usually they will put with the escrow instructions. Also specifying what it is that they will do and what they will not do. You know, they don't go out and inspect the property. They don't make any representations as to the validity of any documents and that stuff. So they have their own general inspections, general provisions that they put in their escrow instructions. But all of these are automatically escrow instructions from buyer and seller, the principals, to escrow. So it's automatically done. In fact, what escrow normally does and what they put in their escrow instructions is these escrow instructions do not supersede the residential purchase agreement. So even if they make a mistake on the escrow instructions, what does the contract say? Because that's the actual agreement. Escrow is not an agreement. It's not a contract. A contract is an agreement between 2 or more parties to do or not to do a certain thing. Those parties. Escrow are instructions. They are from both parties instructing escrow how they will proceed and what escrow is going to be doing. They're not a contract. It does not supersede unless it's an addendum or an amendment. Anymore, they require us to do addendums for those changes. All right. It says there in B, buyer and seller will receive escrow general provisions, if any, directly from the escrow holder. To the extent that the general provisions are inconsistent or conflict with this agreement, the general provisions will control as to the duties and obligations of the escrow holder only. So they only mean something to the escrow holder. They don't mean anything to the buyer and seller for their agreement. Copies of this agreement. The copy of this agreement, including the counteroffers and addenda, shall be delivered to escrow holder within 3 days. So you listing agents, those of you that are opening up escrow, you have 3 days after acceptance, right? 3 business days. So if it's Friday, you don't count Saturday and Sunday, and it's Monday is a holiday, it's Tuesday, right? So we'll get into all that in a minute, my favorite paragraph. But in this case, within 3 days, it is the listing agent or whoever's arranged for escrow duty to get these documents to escrow so escrow can do their escrow instructions. It says here, the agents are not a party to the escrow except for the sole purpose of compensation. We are not parties. We do not tell the escrow what to do. Now, we may be left with that information. The seller and buyer may say, well, I want to make sure that this and that, and you are on their authority going to make whatever changes, but it is the buyer and seller that ultimately direct escrow, not you. You have no authority over escrow whatsoever, even as the agent of the buyer or the seller. Only the buyer and seller are the principals that are parties to the escrow. We are just there for our compensation period. Okay, goes into invoicing and stuff like that might be required. Deposit of funds. Once escrow holder becomes aware of any of the following, escrow shall immediately notify the agent. If the buyer's initial or additional deposit or down payment made pursuant to this agreement is not good at the time of the deposit. So it's the escrow's responsibility to notify us immediately if the funds that are submitted are not good. They get a bounce check. All right. It's up to the listing agent. It's up to the buyer's agent and the listing agent to make sure that the buyer's deposit gets there. And it's not that we have to do that anymore. We don't physically, the buyer will transfer the funds, but it is the duty of the buyer's agent and especially the listing agent to check with escrow if they got the funds. That's something that is responsible. That's always been a conflict between agents and escrow. Well, it's the escrow's responsibility to notify if they don't get the funds. No, it's not. It's their responsibility to notify you if the funds are no good. It's your responsibility to follow up and make sure that the funds get there within the 3 days of agreement. Selection of service providers. Agents do not guarantee the performance of any vendor, service, product provider called providers, whether referred by agent or selected by buyer, seller, or other person. Buyer and seller may select any provider of their own choosing. So it's in writing. We're telling them they have the right to select any of their own service providers. We say that we're not liable for the work that they do, but if we give the buyer or the seller somebody to do repairs, somebody to do termite work or whatever, there is in California something called vicarious liability. We become liable for the work that they do. That's why I strongly suggest when they ask you, who should I use to do termite, give them a list of 3 and let them choose. That way it takes the vicarious liability off your shoulders. Instead of saying, well, I always use. Doesn't matter what you always use. If they say, well, let's use who you use, great, but here are 3 to choose from, and you can choose any one of the 3. No, we'll use the one you use. Fine, that's okay. Get it in writing. MLS service that they have the offer and acceptance are all going to be put into the MLS. Attorney's fees and costs. Attorneys draw up the contract. They make sure that they get the opportunity to get paid should anything arise out of this to be in conflict. Assignment and nomination talks about the right of the buyer to assign their interest in this automatically to a trust or any entity that they own with the seller's permission as to anybody else. And after a certain period of time, all that was spelled out in the original purchase agreement. Up at the top, I should say, equal housing opportunity, property sold in compliance with federal, state anti-discrimination laws, which are, I'm colorblind, everybody's money is green. You can sum up the entire discrimination laws that are on the books with that statement. I don't know. Everybody's money is green. Are they straight? I don't know. Everybody's money is green. Are they gay? I don't know. Everybody's money is green. It doesn't matter. I don't know. Everybody's money is green. that makes you colorblind to the green. That's it. All right. Definitions and instructions. My favorite part of this contract. There's a broker in town here that owes me $1,500 that the bugger never paid me based on this particular clause and document. So spend time. You need to understand what these words mean. That's what these definitions and instructions are, to specify exactly what is meant and what is written into the contract, because trust me, most of y'all have a different opinion of what it means from what your client thinks it means, from what the other agent thinks it means, what the other party thinks it means, what escrow thinks it, what I think it means. Chances are there's going to be a difference. So we always have to come back to this paragraph 25 to go through it. So let's check it. Acceptance. Important word, guys. Means the time of the offer or final counteroffer is fully executed in writing by the recipient party and delivered to the offering party or party's authorized agent. So you don't have acceptance. This does not become a legal, valid, and binding contract until the last signature is signed and that signature, that document has been delivered back to the other party or their agent. So we get a counteroffer from the seller. Do we have a legal, valid, and binding offer? No. It is only legal, valid, and binding until we, the buyer's agent, get it signed and we send it back to the listing agent and or seller. That's when we have a legal, valid, binding contract. That's the date of acceptance. Why is that important? Because all of the timelines and everything in the contract go back to that date of acceptance, not to the date that's at the very top of the contract, that is the date that you wrote it up, the date that the property was accepted. In commercial properties, they don't even set the date of acceptance. They leave that up to escrow to do it. They don't even know what the date of acceptance is until they open up escrow and escrow states what the date of acceptance is. Our date of acceptance is going to be based upon when it was signed and when it was returned back to the offering party and an email to them, the way the contract is written up, and we'll see next time when we get to the last page, that if you put your name in there as the receiver, being able to receive, all it has to do, the email, all it has to do is make it into your email box or to your documents, whatever it is, and it's deemed accepted. It's deemed that it has been delivered. So we'll talk about that more specifically. I think we're talking about that on Thursday. Agent. It doesn't mean you. It doesn't mean me. It means all of us. It means the broker, salesperson, broker associate, or any other real estate licensee or licensed under the brokerage. That's the term of what agent is. Now, the agent to the agent, as far as who represents ultimately the principals, is the brokerage. You are agents of the broker, but in the grander scheme or in the purpose of the purchase agreement, agent includes you too, you as well. Agreement, the document, and any counteroffers or any incorporated addenda forming the binding agreement between parties. Addenda and amendments are incorporated only when signed and delivered. So let's say that you have this offer and you get a counteroffer and the counteroffer gets back and gets sold, but then they also, oh, well, we want to give this addendum to the counteroffer. Well, if they've already signed the offer and the addenda and the counteroffer and the addenda is not mentioned in it, in other words, not made part of that, it comes after the signing of the counteroffer. That addenda does not become part of the agreement until signed by all parties. It means nothing. It doesn't exist. Well, we sent them an addendum signed to get this work done, and they didn't do it. They don't have to. They didn't agree to it. It wasn't part of the agreement. Now, if the addendum is attached to the counteroffer that goes back, yes, you don't have a deal. You don't have fully accepted offer until they accept also or negotiate out what's going to happen with that addendum. As is condition. I hate this term, but it's used here, so we have to deal with that. As is condition, the seller shall disclose known material facts and defects as specified in this agreement. So as is really means as disclosed. We do not have a true as is sale price. So you can't, even a property that is owned by a bank who has absolutely no disclosure responsibilities cannot truly sell a property as is where is, because there are still requirements such as title and other federal laws that have to be, even though they never owned it, they're still responsible to make certain disclosures under federal law. They may not have to make them, they don't have to do the TDS and SBQ when a bank takes a property back, but they do have to do federal lead-based paint. They do need to do NHDs. So again, it's no such thing as is. They're taking it at where is as is, period. I don't have to do anything. No, seller still, and you, the agent, has to do your job of disclosing any material facts or defects. What is a material fact? That's a really broad legal term that says anything that might change the opinion of value is a material fact. Anything. Doesn't even have to be written down in the law. They could find out some time period from now that, the air in the city was somehow a material fact 10 years from now. That's why we have insurance for these things. Buyer has the right to inspect the property with the time specified and request the seller make repairs or take other corrective actions. Now, see, that's one of the things that agents mistakenly think is that when they put in the properties being sold as is, that the buyer and a buyer accepts that they are waiving their inspection rights. No. In fact, some of their inspection rights can't be waived, period, by law. They can't get, I've had corporations, companies that are buying and flipping property say, I don't care, I don't want any reports, I don't care about it, we're going to redo the whole house anyways. Now, they cannot waive that. It's not waivable. It's not in the public interest. We still have to do the inspections. We still have to do. Now, they may choose not to do an inspection. That's entirely up to the buyer. But the right to have the inspection cannot be taken away by the seller. It's guaranteed under law. Authorized agent means any individual real estate license specified in real estate broker section. That's the one we're going to look at, where you authorize yourself to receive any communications on behalf of your client. CAR form means the most current version of specific form referenced or another comparable form agreed to by the parties. We always want to use the latest CAR form. Now, sometimes other companies don't. They have, photocopies, or they have saved copies on their Win forms or on their ZipLogics, and they don't update them. As long as the form is comparable, I mean, there's always some little change. Like right now, there was a discussion yesterday on a purchase agreement where they used the previous purchase agreement that had some verbiage in there about the SPBB, the sellers, that doesn't exist anymore. The new form took that out. We don't have that, but that's about the only change. So generally speaking, they can't get it anyways. We don't want a copy of their buyer broker agreement, so it's kind of negligible. But we want to try to use the most up-to-date contracts and disclosures because they comply with the law. And sometimes they are so outdated that our E&O insurance won't cover us. So always choose to use the latest CAR form. And if you get an old contract that is not the current one, you have them do it on a new contract. Insist that they do. And you should have insisted, your client insisted they do. Close of escrow means the date the grant deed or other evidence of transfer of title is recorded for any real property, or date of delivery of the documented evidence of the transfer for any non-real property transactions. Okay, close of escrow. This is where I kind of started making money, because even attorneys will have a differing opinion on what close of escrow. I got a letter one day from a seller that was an attorney, wrote it right on her letterhead, her company letterhead, attorney LLC, blah, 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 blah. And she said, I do not have to move out of my house on such and such a day, 3 days after the close of escrow, because the close of escrow is defined as all cessation of labor. Well, since it was closed on Friday and I didn't get my check until Tuesday or Monday or whatever it was, Therefore, that is the close of escrow day. So I have 3 additional days. So she even wrote it down. I sent her a copy of her agreement here, highlighted this section saying, no, the close of escrow is not the cessation of labor. The close of escrow was defined in the agreement that you agreed to, Miss Attorney, as the date that the grant deed or other evidence of transfer of title. So it happened on Friday. You got 3 days after Friday to get your butt out. I never heard back from it. Copy means copy, including photocopy, facsimile, and electronic. Remember, in the days prior to these electronic documents flying all over the place, we had to have real live wet signatures, not to be valid, but to be admissible in the court of law. We had to have wet signatures. The seller and the buyers combined would have to bring their contracts together to go to court, because the seller's agent had the seller's wet signatures, the buyer's agent had the buyer's wet signatures, and the court required wet signatures from everybody to rule on something. Today, it's different. We have permission here, and the law allows for photocopy, facsimile, and electronic signature. So that's why whenever someone circumvents the law and will actually create an electronic signature illegally, they take it very seriously, and it's being investigated by the district attorney. The DA is looking at those things. That's a criminal action. So making any fudging, we don't fudge, we don't change dates, we don't line them out, we don't write them out and rewrite them in. Don't do that. Bad, bad, bad. Counting days. Here's the big one. This is the one that always seems to get everybody, when everything especially goes sideways. The first thing that they want to do, well, when is the 3rd day, or when is the 2nd day, or when is this, what? Okay. So it says, unless otherwise agreed, the first day after the, whoa, sorry about that, guys. There we go. Okay. The first day after the event is the first calendar date following the event and ending at 11:59 p.m. So when you count days, we're going days after. So it's 7 days after. We don't count the date that the contract was signed. It's the first full day after the contract was signed is day 1. And that's what they say here. They got an example of a notice of buyer perform. And the notice to buyer perform is delivered at 3 p.m. on the 7th day of the month. The 7th day is day 0. It doesn't count. The 8th becomes day 1. And then 9th and 10th and 11th. Ending at 11:59 p.m. of the last day. It's all specified as to when those dates will end. Okay? So we don't count the date up. We don't count the calendar date that they accepted the offer. We don't count the date that we gave them the notice of buyer to perform or whatever other notice. It's always the next day or days that we count, ending at 11:59 p.m. on that final day. Now, it says if it's after acceptance and what they call the scheduled performance date is, let me just go down here and highlight this whole section. After acceptance, so after the agreement's been accepted, and one of those dates, the 7th day, the 17th day, the 21st day, the 30th day, whatever those dates are, close of escrow, 30 days later, right? If the scheduled performance date, the 30th day, for an act required under this agreement, including close of escrow, lands on a Saturday, Sunday, or legal holiday, the performing party shall be allowed to perform on the next day that is not Saturday, Sunday, or a legal holiday, called the allowable performance day, and ending at 11:59 p.m. that night. Okay? So if the close of escrow falls on Saturday of a 3-day weekend, the seller can't go back to them and say, I want their deposit because they're in breach of contract. No, the contract allows them to go through to Tuesday at 11:59 p.m. to close the deal. Got it? Questions? Because this is always one of those areas that people come back and ask me question after question. All right. Days mean calendar days or days. However, the deposit of escrow is based upon business days. Okay. So calendar days are every successive date. except for the deposit. If the deposit's due 3 days after and the days after ends up on a Sunday, it rolls over to Monday. Doesn't count. It's a business day, 3 business days. So it'd be, if we wrote the offer on Saturday, Monday, Tuesday, Wednesday, 3 business days. We don't count Saturday or Sunday. Delivery, delivered, or deliver. Documents, unless otherwise agreed, means they shall be effectively upon personal receipt of the document by buyer or seller or their authorized agent. Personal receipt means a copy of the document or the link to the document is in the possession of the party or authorized agent, regardless of the delivery method used, i.e. email, text, or Dropbox or whatever. A document or applicable link to the document shall be deemed to be in possession if it is located in the inbox of the party or the authorized agent. So just emailing the link, emailing the document, emailing whatever, or putting it into the hands of the other party is considered in possession. So even the link to the document is in possession. Why is that important? Because that's where we're going to have a legal, valid, and binding agreement or document or whatever it is, having it in their possession. And that includes things like Dropbox, Google Drive, or other equivalent programs, if it is specified within the agreement. Electronic copy, electronic signatures. Again, prior to 1985, we were not allowed to use. We had faxes, obviously, in those days, but even a fax signature wasn't good enough. It had to be a wet signature, and it was President Clinton that signed in the Electronic Transactions Act into law in about 85, 86 that allowed electronic signatures to be admissible into the court of law. Law meaning code, statute, ordinance, regulation, rule. Legally authorized signer means individual has authority to sign for the principal as specified, and we'll look over where we do that. Otherwise agreed means an agreement in writing, signed by both parties. Otherwise agreed does not mean an agreement, a verbal agreement. That's not otherwise agreed. Okay, you can have 17 days or 27 days instead of 17 days. Oh, great, thanks. But we don't write it down. It's not an agreement. It's not otherwise agreed. Verbal agreements are not admissible in a court of law under the statute of frauds. So therefore, we have to have everything. It has to be written down. It could be a memorandum. It could be an email, a text. That's a form of writing. That will suffice. Repairs mean repairs including pest control, alterations, replacements, modifications, retrofitting of the property. Sign or sign means handwritten or electronic signatures on the original document, copy, or counterpart. Shoot. Okay. All right. Any questions, comments about this today? And I really want to make sure you have a good understanding of these definitions. Yeah, no?
Just a comment, regarding acceptance, I'm sorry, regarding as is. I had always understood as is exactly that, but I never related it to the fact that there has to be disclosures anyway. But it's a good point. It's good to point that out, because when you're explaining to your clients, and I had that with the last client, the last seller who just closed last week, where we talked about as is. And I think the way that I explained it to her probably confused her. So it's good now that I am very clear in terms of what as is means versus disclosures. You have to disclose certain things, because that was her issue.
Yeah, of
The
course.
disclosure of a previous flood.
I've sold it as it, and you know, the problem is not so much sellers or buyers. I don't think that they really understand the nuances that well. It's the agents that think they know what they're talking about. They're the ones that are really driving me crazy. You know, you get an offer to purchase, or you submit an offer to purchase to a listing agent, and they come back, the property is being sold as is, whereas, with no warranties, and just right. You hear that phrase all the time. And then 2 weeks later, they do a purchase or they do an inspection and they make a request. We said, well, no, we said that we're not doing any. I get that you said that you weren't going to do any replacements, but I'm still asking. Well, you can't cancel. Oh, yes, I can, because I still have inspection rights. And if I don't like the property in the condition that it's disclosed in, then I have the right not to buy. So yes, I do, when I'm having a discussion with my clients, I'm saying, folks, this says as is, but I want you to understand in California, under California law, it's as disclosed.
Yeah, that's good.
That's, and that, what that means is the condition of the property on the date that the buyer saw it and made the offer or saw the property, that is the condition of the property, but subsequent to the disclosures that have to be made by the seller later on. Great question. Great observation. Thank you. Anybody else?
Hi,
Right.
Peter, I have a question.
Yes, go ahead.
The electronic signature section you were talking about, I see a lot more people putting in a disclosure for electronic signatures. Is there anything that we need to do on that now?
I know I do not. Okay. Remember that most of the people do things based upon their personal experience. I tend to leave it up to CAR, which is their duty, and I mean they're the ones that are attorneys. They are the ones that work with the legislature on these. And if they have a disclosure, I tend to use that. I don't like using my own because, first of all, I'm not an attorney. I may sound like it, but I'm not. And I'm not paying an attorney to draw up a disclosure to protect us against electronic signature. There's law. There's enough case law. There's enough information out there regarding electronic signatures. There's an entire law written by, again, Bill Clinton in those days as to what electronic signatures are. So having a separate disclosure for explanation of electronic signatures, it's here and it says what it is. Electronic copy of the signature complying with California law. That's really all that needs to be said. Oh, what is California law? Go look it up. But there are those companies and there are those agents that want it.
Okay, thank you.
Sure. No, I got agents. Trust me, I have an agent out there. She's a great agent, but it drives me nuts with all of this. And I laugh about it because I'm always pointing out that CAR is in the business, used to be in the business of selling forms. They don't sell them anymore because we used to have to buy these things. But the thing is that they have forms explaining their forms. I can't, at what point do we stop explaining things? Literally, we have a TDS and then we have a disclosure regarding explanations to the TDS disclosure. Yeah. At some point, somebody's got to grow up and be over 18. And real quick, I'm going to take you down here to what we've been talking about, and I'll touch on it again on Thursday. But remember, I said that acceptance is when the document has been signed by the last party and that acceptance has been delivered to the previous party. And it could be buyer or seller. You know, it depends on if we're in a counter to a counter to counter to an addendum or whatever. Whoever the last party, seller or buyer that signs it, we don't have a legal, valid, and binding contract until that acceptance has been delivered to the offering party, the offeror, right? So here is where we designate who is going to be able to receive any and all of these documents as we go through there. So for the buyer, obviously the buyer is here and they signed and they're the buyers, they are the principals of the agreement. Or you check, and you can check the box, the printed name of the legally authorized signer. All right, so you would check that box and their name. Could be that we're signing as a for an entity, for a trust or whatever, and you would put title, you know, trustor, trustee, whatever. But here, down here, it's, you know, it gets into at the bottom here where you give yourself the ability to receive those documents. So here under the broker section, it says here at the bottom, designated electronic delivery address, email, or in this case, it could be, you know, Dropbox or Google app, whatever, people use different things. So the moment you put in here the address, phone number, you put in the email address, and you put in the designated electronic delivery, email or text or whatever you want, then that becomes, that gives you the authority to receive those documents electronically. So that's the signatures and the electronic delivery address. So this is where we give ourselves permission to accept on behalf of our client any of those documents. And remember, the moment that it's emailed to that, because the alternative to that is to give the other side your buyer's direct email or text number or whatever. So we don't want to do that. So we give them ours so that we remain in control. Then we would fill in, you have to fill this information out in here in order to give yourself the approval to be able to get that. So, and then there's a form attached, DEDA, if the parties have elected to an alternative direct delivery method, then we will use the DEDA. That is for the Google apps. That is for the other stuff. And there's hundreds of them. I don't know them all. I just know of Dropbox and Google Documents. There's probably other document collection forms out there in the internet, but that's where you would put that on the DEDA. All right, I'm done. Anybody else? Questions, comments, concerns, hallucinations?
Well, Peter, this is kind of off topic, but it's regarding the recent language. Well, do I want to say language changes from the MLS? Days on market versus DAM now, days active in MLS. And I'm just a little confused. It says the calculation method for these terms will stay the same. So the way DOM was calculated, days on market, as of yesterday, is the same way DAM, days active in MLS, is calculated. What do you know what the reason for that change is?
No, and this is that is not contractual, which is what we're talking about here between buyer and seller. That is what the MLS has deemed as their practices and what they require for us and how they're going to accumulate that data. So no, I have no idea why they did it, or I don't even know what exactly it means. I haven't looked at it.
I don't either.
Yeah.
It's
send me whatever it is you got. I'll look into it gladly because I'm interested in that stuff, but I have no idea.
Okay, it was just came from the California Regional MLS today.
Okay, I haven't looked at my emails today. I've been in meetings all morning, so
okay, thank you.
Forward it to me just in case I didn't get it.
Okay.
All right. Any others?